Hello, everyone, and welcome to Uncivil Law. In today's case, we have a prisoner who was beat up on multiple occasions by fellow prisoners, and the guards may not have done anything about it, even though they perhaps knew about it. This is the case of Philip Roberts versus Coffee County, Tennessee. In this case, Philip was in jail. And it didn't necessarily go super great for him in terms of his physical protection. So we're going to read a little bit about what happened to him and whether or not there's any liability from the prison for the mistreatment by fellow prisoners. Let's get started with this. Roberts was booked as a pre-trial detainee into the Coffee County Jail in May of 2017. Upon his arrival, he was assigned to a cell in the AD pod. Roberts complained to the classification sergeant about being assigned to this particular pod, warning that he'd have a problem because there were informants in the pod who had tried to set him up. So he says, there's people here who, I'm going to have a conflict with. Roberts was attacked by multiple inmates in the pod. Roberts had apparently smuggled tobacco into the jail and smoked cigarettes after lockdown the night before, and inmates had smelled it and concluded that he was the one smoking the tobacco. The inmates approached Roberts in his cell, asked Roberts for tobacco, and when he refused, they kicked and punched Roberts for several minutes, resulting in a black eye, cut lip, and several bruises. Roberts asserts that he informed the prison guards about the attack and he asked for a transfer. So we have this first incident with this guy. Roberts comes into jail as a pre-trial detainee. He's put in a place where he says there are informants there who try to set him up. And apparently he had smuggled in cigarettes and some people wanted him and he said no. And he says he got beat up pretty bad and he told the guards about it, but nothing really happened. All right. Roberts remained in the AD pod and continued to possess the tobacco somehow. And the inmates who attacked him continued to threaten him because they wanted a piece of the tobacco. So 4 days later, after this first incident, Roberts was again attacked in his cell by some inmates for again refusing to give the tobacco, which somehow he still had on his person 4 days later. Roberts claims he spoke with the guards after this attack and asked them to convey his request for a transfer. And he also wrote a kiosk request, because apparently there's a kiosk you can make requests on, to be transferred. But still, even after this attack, he was still not transferred. And then a week later, Roberts was again attacked by some of the same inmates. Roberts complained about the attack again, and he was then transferred to a different pod 3 days later. Despite his claims that he made repeated complaints and requests for a transfer, there is no other jail documentation that, except for the last transfer, that exists to support the testimony. He made complaints and requests for transfers to guard and through the kiosk system prior to transfer. So other than the last request, there's no documentation. He made another request according to the jail. The jail testifies that they had no knowledge that Roberts was assaulted or he had requested a transfer for his safety. And if he had made such a request, it would have been documented. So we have a dispute of fact over here is about to what the guards knew and when they knew it. What did they know and when did they know? So Roberts says, I was attacked on 3 separate occasions, and I'd asked for transfers, incidentally, 4 times, because I asked for a transfer before I ever came in the first place. And I told you about the first attack, and I told you about the second attack, and you kept me here anyway. And I also made a kiosk request, and you say, well, there's no documentation that you made any of those requests. There's no documentation of this kiosk request. And so we knew nothing about you being beat up on these requests. We knew nothing about it. And if we had, we certainly would have written it down. So there's a question of fact, who's telling the truth and who is lying in this situation. And so the question is, can we go forward based on this or not? Can we figure out what's going on? Or is there qualified immunity as a result of all this? So qualified immunity, or do we go back to trial to figure out who's telling the truth? Let's carry on. According to the chief deputy, the AD pod is not known to have any pervasive issues with inmates on assaults on inmates. So this is not something we know about in this pod. Okay. And the other guard testified that the Roberts intake assignment did not suggest Robert needed protective custody or was in high risk of assault. So the risk assessment said, this isn't going to be a problem. Okay. The Coffee County Jail has a policy and practice of transferring inmates known to be in danger of assault, one would hope. The kiosk system that he apparently made a request on is managed and maintained by an outside company. And the jail at least claims that no one at the jail can delete or manipulate the entries. So they say, well, we don't have any control over this kiosk. We don't have any record of it. Therefore, he didn't make a request. Okay? So the question here is deliberate indifference. Did the guards knowingly, or at least passively, allow this guy to get beat up even though they knew better? What was the state of their knowledge, and did they just not care? So do they have deliberate indifference or not? Let's discuss more. We first address Robert's claim against Strange and Carroll for their alleged deliberate indifference to safety in failing to protect him from harm. As a pre-trial detainee, his claim is governed by the 14th Amendment Substantive Due Process Clause, which we generally analyze as the same as claims under the 8th Amendment's Cruel and Unusual Punishment Clause. Carroll and Strange, the guards, argue they're protected from qualified immunity because, of course, they do. To rebut the qualified immunity defense, the jail inmate must show that the jailers violated his constitutional rights and the unconstitutionality of their conduct was clearly established at the time that they acted. To succeed on a claim for deliberate indifference as a violation to his safety, Roberts must make a two-part showing the risk of harm was objectively serious, this was really a problem, and that they were subjectively indifferent to the safety. So there was a real threat, and subjectively you didn't care. An official is deliberately indifferent if he knows of and disregards an excessive risk to health or safety. Excessive. The official must be both aware of the facts from which the inference could be drawn and also must draw the inference. So in order to be deliberately indifferent, you have to know about the facts and you have to draw the inference that there's a problem and choose not to act anyway. So did they actually know? Did they fail to draw the indifference? So was it objectively a real threat? And subjectively, did they actually know that they were disregarding that threat in careless disregard to his safety? The jailers argue that summary judgment from the trial court was appropriately granted because there are no jail or medical records corroborating the assaults or the injuries. And they say this is simply impossible if the events occurred as he described. There's no records of these assaults, there's no medical records, and that couldn't possibly occur in our jail. The jailers also point out that Watkins testified that Roberts had reported the assault to the guards or through the kiosk system. There would be records of the incident because jail personnel cannot delete these entries, and jail staff with knowledge of an event always create an incident report, I'm sure. However, neither side's evidence is conclusive, so the argument simply raises a credibility question, whether Roberts was telling the truth when he testified he made numerous reports, or whether the assurances are correct, the records of the event will still exist today if the events occurred as he said. So the Court of Appeals saying is, look, this is a factual question. What's actually true? You know, can you delete it? Can you not? Do you have access? Do you not? Did he make these reports? Did he not? Did you know or not? These are all questions of fact. And the fact that you say, well, we don't have any records or anything is not conclusive. So, you know, who's telling the truth, that's for a jury to figure out. But, you know, this is factual questions. So not appropriate for summary judgment. Yeah, makes sense. Although some of the evidence that is offered by the defendant is inconsistent with Robert's testimony, Robert's version of events is not blatantly contradicted by the record, such that no reasonable jury could credit his testimony that he was assaulted and reported to the guards. So there is some evidence that goes the other way, namely that there is no records, which is in of itself a kind of evidence, but that isn't conclusive. Thus, drawing all reasonable inferences in Robert's favor, as we must at this stage of proceedings, because we have to take the complaint in the light most favorable to the person making the complaint, a reasonable jury could conclude that Roberts was assaulted by other inmates and he did report those to the guards. So the jury could believe him if they choose. Thus, turning to the objective prong as to whether or not this was sufficiently serious, Roberts testified that he was assaulted by inmates as a result of smuggling tobacco into jail, and he reported the assault to the jailers, and he requested transfers to a different pod of the jail for his safety. He then claims he was assaulted by inmates twice more, each time reporting to the guards, but he was not moved until 3 days after the third assault. Based on the evidence, a reasonable jury could conclude there was a substantial risk of serious harm if he remained in the pod with the inmates who had already attacked him. So that would be an objective thing they could believe. As to whether or not these jailers were subjectively aware of the threat and consciously disregarded it, the jailers argue they were not subjectively aware of the risk because they were not aware that Roberts was in possession of tobacco that other inmates had wanted, and there's no reason to suspect the inmates would continue to harm Roberts. However, drawing all reasonable inferences in favor of Roberts, a reasonable jury could conclude that they were subjectively aware. It's a question of fact. What did they actually believe? After the first assault, that he'd been assaulted by inmates and requesting a transfer. As Robert testified, he had reported when he displayed visible injuries. And Watkins testified an inmate report of assault and request to be transferred would be routed to a shift leave or classification officer. Finally, the jailers argued that Robert's claim against them must fall because he suffered no more than minimal injuries, so they're not serious enough to count. Okay, in making this argument, the jailers ask us to ignore his testimony that he took kicks and blows to his ribs and legs, and he felt like the inmates were trying to put him into a wheelchair. And his testimony that his leg is still worse to this day because of the assault, and he's had to hold the wall to sit down and use the bathroom, so he's still been injured seriously. So your claim it was just de minimis is a little bit belied by his argument. Thus, drawing all reasonable inferences in Robert's favor, a reasonable jury could find he suffered more than minimal injuries from the inmate assault. As Robert points out, the nurses did not examine him until after 3 weeks after the second assault, and they prescribed him medication that was used to treat pain and swelling. Her notes also reflect that he had decreased range of motion in his back. Even if the doctor or nurse's notes and testimony could rule out that he suffered major injuries, a reasonable jury could find that he requested medical attention promptly, and the pain he suffered more than 3 weeks after the assault were more than the de minimis injuries. So that brings us to the end of the case of Philip Roberts versus Coffee County, Tennessee. In this case, we learned that Mr. Roberts was a prison inmate, but he hadn't been convicted. It was pre-trial detention. And he argues that he was beat up multiple times and made multiple reports, and the officers just didn't care. And the officers said, well, there's no records of it. And the Court of Appeals says, well, that's an issue for the jury. If they want to believe him or believe you, that's up to them. But this can go back to trial. You don't have qualified immunity if they believe you, because you do have a duty to protect that you violated if you were in conscious disregard. So at least for the moment, that brings us to the end of the discussion of this case.